with the PRTTs and so forth. We say the application was made pursuant to, instead of saying pursuant to 3233, we're pursuant to the FISA Act.
Why would they black out the specific
Classified. Then information is either still classified, or if you look at the little markings next to it, those are FOIA redactions. So the Freedom of Information Act says that when information is released, you can hold back information for certain reasons. So like B6 is a common law enforcement one. I can't remember what B1, B3, B7 are, but you can pull up FOIA and see. So they basically are asserting that they can't release this information due to these.
doesn't everyone already know what the FISA Act is?
Yes.
That part is blacked out.
Well, we can't see what the specific statute number is because it might tell us how many different sets of authorities are underneath because they're numerical.
Okay.
Yeah.
Okay, thanks.
So it might be like, so it's 50 USC instead of 18. It may be like sections, 1 to 5, and we're like, oh, there's at least 5 sections because they go numerically.
So that's interesting. So 50 is not criminal code.
No, I don't remember what 50 is. It would be one of the national security-ish type ones. Yeah, I actually thought this would be under 18, but it's not. Yeah. So we have to assert that Russia is a foreign power. I love how some of these things you get, and it's asserting like things that you would be like, well, duh, like very basic facts, and yet because the statute requires it. So I'm saying you probably have to assert that because it says it can only be used against a foreign power. So we can essentially reverse engineer what the statute is requiring by looking at this warrant, at what they didn't redact out. And we say Carter Page is an agent of Russia, so that must be required. The minimization procedures proposed in the application have been adopted. So FISA 702 is minimization procedures is this whole thing. I don't even want to touch it because it's a hairball. You should research it. It's cool stuff. It's a hairball. And then he has to say, similar to what we say in a lot of the warrant ones, that all the certifications required by statute have been met here. And notice again, they blacked out the statute number. So we can't tell which statute is requiring these statements. We can say it's not clearly erroneous. So this is probably another statute requirement that is in there. That's not text that we usually see in a warrant one. Pursuant to the authority conferred on this court, we're going to say the United States is, I'm at the top of the second page, the United States is authorized to conduct blank of the target as follows, and this is where they're going to be saying, like, you can get the email subject lines, you can get the URLs, whatever they're actually getting here, because we don't know because it's been FOIA'd out. I didn't go through the whole thing, but it was kind of interesting sort of going through all this and seeing the pieces. It's pretty long.
This was released by the House Select Committee on Intelligence, right?
It was released, I think, it might have been released by DOJ. You might be right, I don't remember.
But it was supposed to be like evidence undermining the Mueller investigation, and yet I don't see how it serves that purpose.
It's so blacked out. Yeah, I mean, I was mostly interested in it because I never particularly thought this through, but it makes perfect sense that this is facially similar to the non-classified warrants that we handle for regular wiretaps. Yeah. So this is just a little bit of notes about 702 allows the targeted collection of content. About collection to, from, and about the target, we can do a couple different hops around. Backdoor searches are basically where we already have this data available and the FBI has a target and they want to go see if there's anything in the already collected data about it. The last ODNI transparency report, so there are 129,080 individual groups or entities who are targets. So, after we just went through all these statutes and I said, case law doesn't really have much to do with it, we're going to touch on All Writs Act, which is kind of case law and is very fuzzy and is a weird, wiggly little area. This is kind of a catch-all because especially all these things have very specific requirements. Way back in 1789, they decided we better make sure we can always get the information we need, and we're going to make this All Writs Act. And it was actually enacted to enable courts to always be able to go get the information they needed to pursue essentially their role. So 99.999% of the time that this law is used, it's by a court basically saying, I need you to go do something like some really arcane, small, like land dispute or something. Like, it's not a big deal. It gets used all the time. Most states also have a version of this for their state courts. But it got used for the Apple iPhone unlocking a couple of years ago. Essentially, the FBI had, the phone. They wanted the phone unlocked. Apple was like, sorry, we can't unlock that for you without writing custom software. This didn't fit in a box of like a wiretap or stored content or something because they wanted Apple to go affirmatively write some new software to do this. And there's not really any provision to do that in our current wiretap statute or so forth. So essentially the All Writs Act says anything necessary and appropriate to aid in the respective jurisdictions. I like this wording, agreeable to the usage and principle of law. I'm not sure how that says I'm going to require a software engineer to go write some code, but DOJ said it was. So United States versus New York Telephone is a case that predates CALEA. And essentially this was, they wanted to essentially install a wiretap. And because CALEA didn't yet exist, the phone company was like, sorry, like we don't have the tech set up for you to tap this, like we can't really help you. And they used the All Writs Act to force essentially the technical assistance that is now codified in CALEA. And they said in this case, basically we agree, the federal courts should not just require third parties to do like anything. They were kind of leaning on it then because they're like, well, clearly, like we have this wiretap sort of law. We should be using it. You phone company are just being annoying, and so we're going to force you because it seems kind of clear to us that you should be allowed to do it. And so essentially what happened with the All Writs Act case with Apple was, they found like some other way to get in because software is always buggy and there was essentially a backdoor to it. But they have not said they won't try this kind of thing again. So if there's another fight over this sort of thing, if we do not have essentially a new version of CALEA that would require writing, software doing other work to affirmatively unlock phones or other devices, All Writs Act could come back to play again. So these are my sources. There is a lot of very boring government manuals up here. I will definitely tweet out my slide deck if you don't want to try to take pictures of super long URLs. Lawfare blog in there is a very conservative blog, but they have people who really know what they're talking about, and so I find it a somewhat interesting read. The thing at the bottom is a book. So when you go to law school, you actually really learn law through like the supplements, and this is a very good horn book that basically taught me Crim Pro. And the top book is an insanely expensive book by David Chris that if you have access to a law library that has it, will basically teach you FISA and so forth. It's very good, but it's like $500 for 2 volumes or something insane. So try to find it in the library. So I think, do I have time for a question or two? Okay, oh wow.
Is this basically the same for wireless surveillance? Like if I was going to bug somebody, this is mainly wired. What you're
How
talking
would you
about
be
now,
bugging,
right?
like you individually doing it?
Yeah, well, I mean like law enforcement. So
Via-
basically my question is, this is mainly wired. Would the laws be that much different for wireless?
This
Like
is
if I
applies
was-
to cell phones.
just to cell phones and stuff?
Yeah.
Okay.
Yep.
No, not wireless, like electronic surveillance. Like I actually have like a spike mic, pointed at you, and so I'm recording.
It
the
technically
conversation.
falls under this, yeah.
Oh, okay.
Any of that done by law enforcement, something like that. This sort of, like, if you are one person recording, you need a one-person consent or a two-person consent in your state. Anything outside of that is criminal, and you should not do it.
Well, not me personally.
Yeah.
Personally, yes.
Please don't wiretap your neighbors.
Hi there, awesome talk. So you noted that the wiretap sort of extends to if I swap a SIM in an existing device, then they don't have to go and get a whole new wiretap order, right? They can continue to use the existing one even though the phone number changed because the device identifier is the same.
Or whoever they're keying the identification off of, if it shifts, you can often follow it.
So does that still apply if you get a new device?
So the
Because then the phone
IMEI number changes?
Yeah, so the IMEI and the phone number both change.
I'm going to say probably. I think it may depend on the company. I didn't handle ones that were like that, so I don't want to give you a definitive yes or no. That may come down to the company policy. I don't think there's case law on that, but
So it seemed like a lot of the reasons that you were kicking things back was sort of bureaucracy, you know, so
Yeah.
this thing had to be lined up with that thing, had to be lined up with that thing.
the wording has to match exactly.
Yeah. Can that be gained from the perspective of someone who may be a target from this? Is there some way to increase your chances of being a person that makes it, that is more likely to cause a, you know, bureaucratic
Make the
logjam?
Yeah, make the law clerk drafting these get tired and forget to check the statute. But I'm pretty sure that most courts use
You know, like a
basically.
SQL injection in your name or something.
Oh man, we saw some funny names in some of them. Because you don't usually have names, you have known as and whatever. They're like candles or whatnot. Yeah, but most courts are basically going to have, like, on the C drive in the folder orders, they're going to have a, like, PRTT folder. They're going to have a PRTT with a D order, and they're going to fire that sucker up and basically do a find replace. So it's not like they're drafting it from scratch every time.
Hi, thanks for this awesome talk. One question. You were talking about mobile phones so far, but does this also apply to mobile phone technologies, for example, used into connected cars?
It would apply to anything that has an internet connection, essentially. If you can get to a provider and serve an order on them, then they can package in response to the order, package the data up and send it to law enforcement.
So my question is with regards to modification of data that is passed over the wire. Does this only cover, well, you are allowed to record everything that goes over this wire, or are you also allowed to modify the data? For example, enforcing SSL man in the middle or something like that to be able to access the data, because for example in Austria they just changed the law. If you're using Tor or Signal, the government is no longer able to read that if they want to wiretap you, so they now have the right to install a backdoor on your phone. They even may break into your house to install it there.
Yeah.
In order to get access to that data. So are they allowed to modify your device and or your data stream as well with the wiretap?
I'm going to not answer this one.
Okay, maybe I'll move you to an easier question, I hope. So how does law enforcement decide to whom to issue the subpoena, right? I mean, there's no one service provider that's just operating in a vacuum. Everybody's using, you know, AWS and Google and all these other pieces of infrastructure and other vendors who may have access to the same information for whatever
How do they
reason.
choose who to go to when it's a long chain of providers?
Right.
I'm going to guess, go to the ones they're familiar working with. Some of these companies have very large trust and safety programs, and they hire outside counsel and so forth. This is where I did this kind of work. And those are probably easier to work with, and they may get a reputation to be easier to work with, and people go there. I don't know.
I think I've seen some recent laws allowing ISPs to possibly monitor and or alter data going through the ISP. Can you roughly outline that? And,
About the ISPs being allowed to modify data?
Yeah, monitor and modify data, like 6 months ago? New laws?
Sorry, I'm still trying to figure out like so law enforcement gets a wiretap order asking the ISP to monitor or to modify the data that they have?
No orders.
No orders, and they're getting stuff outside an order?
Yeah. New laws allowing ISPs to do what
Right.
they want. And how would that apply to warrant?
I'm just going to say that no client I worked for would do that. I can't say who my clients were. But that's not going to be a common practice among people who have like the big trust and safety groups and whatever, because if you you're following, like you're hiring attorneys to do this checklist, because if you don't, it's essentially illegal wiretapping, which is very serious criminal penalties. So if that's happening, my guess is maybe there's some kind of like a 702 classified whatever thing going on, but I don't know.
Awesome, awesome talk. Just to probably add to that, I'm supporting a client of mine in Australia right now who's looking at a civil activity relating to copyright infringement and DNS blocking, which has now actually become commonplace in Australia. Hit me up sometime during the week.
Yeah, and copyright enforcement stuff is going to be entirely different from wiretaps.
Yeah. Anyway, my question was, I couldn't but help sense going through it. It sounds like everyone has a whole heap of Word docs that they're just doing
Everyone has a...
So it sounds like law enforcement has a whole heap of Word documents that they're just
Yeah.
doing Control-C, Control-V to. Has there been any view to automate and accelerate that process at all? And even clear up some of the data validation piece?
Well, the data that I would see would come from the courts, and courts are notoriously tricky to do nice whiz-bang technology with CPacer. I do think there's various agencies that have various ways to do this kind of stuff. If you go read these manuals, like DOJ CSIPs, they're going to tell you exactly how to create and draft one of these applications. Like, these are very interesting to read. They'll tell you under, like, when you're allowed to use this, what type of investigation, and so forth. As far as automating the legal technology, there are definitely, in terms of the attorneys who do it, they may be doing some automation. I had some because I'm a programmer and this is really boring work. But it's a really high bar to make sure you're always correct. Like, there's not a lot of room for screw ups, and so you know how many bugs happen. Like, you don't want this fully automated.
Nope. Awesome. Thank you.
Okay, so this will be the last question. I'm going to be outside at Lockpick if you want to talk to me more.
Some people alluded to this, but can you do this under any spectrum, even without the internet? There's like 900 megahertz, 2.4 gigahertz, visible light, radar.
You would need a service provider to serve on.
So if there is no service provider, they don't have the authority to create a system that intercept a
That
different
intercepts?
spectrum?
That's a good question. They probably do. I'm not that familiar with those. I'm familiar with the stuff like the things the service providers get. So that's a cool research question you should go look at. I suspect they probably can. I just don't, off the top of my head, standing here with no legal research tools, no. So. Yeah, you want to be very careful about recording anything off of this because there's a lot of laws in this area that are very finicky and have very serious penalties. So, cool. Thank you, everybody. I'm so excited to learn about Wiretap.
Sorry, I got the name wrong at the beginning.
Oh, no worries.
to start. Scoot up if you can. You know, why sit in the back? All right, good evening, everyone. Welcome to Common Ground. This is You're Just Complaining Because You're Guilty, a guide for citizens and hackers to adversarial testing of software using the criminal justice system by Gina, Nathan, and Jerome. A few words before we start. We'd like to thank our sponsors, especially our stellar sponsor, Rapid7, and our other sponsors, Amazon, Oath, and Semly. It's with their support and the volunteers that make this event possible. As courtesy to our speakers and the audience, we ask that you do silence your cell phones since this is being recorded. Are you guys good? Without further ado, let's get this started.
How about that? Oh, yeah. Okay. Someone in the front row said that the mic wasn't working, and he was totally right. Let's start this again. I'm super thankful that you guys are all here to listen to what I think is a super important topic for citizens of the modern world and for those of us who want to understand how technology works, in other words, hackers. It's really important to understand the role of software in the criminal justice system and to have people looking into how it works that are actually going to look for problems, not just the people who have a vested interest in showing that it's working great. I'm Gina Matthews. I'm a computer science professor at Clarkson University. I'm also a fellow at Data and Society. And I'm joined by Nathan Adams, a systems engineer at Forensic Bioinformatics Services, and Jerome Greco, an attorney at the Legal Aid Society. So software is increasingly used to make really important decisions about people's lives, from housing to hiring, to how we find friends and partners, how we navigate the city streets every day, how we get our news. Criminal justice system is just one example of this. The weightier the decision, the more crucial it is that we can understand and question the decisions that are being made. What inputs are being fed into that decision? How is the decision made? Is it correct? Do we have other information that should be considered? Are we using protected attributes like race and gender? Or what about proxies for these characteristics that are just as effective as the actual characteristics themselves? In the criminal justice system in particular, software and complex systems and algorithmic decision-making is used throughout the system. And it is very often black boxes for which trade secret protection, the intellectual property, is considered more important than defendants' rights to understand those decisions. And not only that, there's a lot of evidence of problems. And how are we going to find bugs and fix problems if the answer is always, you don't get to question that. You're just complaining because you're guilty. That does not sound like the recipe for a society we want to live in. In particular, can you imagine being sent to prison rather than giving probation because proprietary software says you're likely to commit another crime? That happened. And you're not allowed to ask how the software made its decision. That's Loomis versus Wisconsin. Having the primary evidence against you being the results of DNA software, but one program says you did it and another says you didn't. That's the Hillary case. Being accused of murder solely because of DNA transferred by paramedics to the scene, not you at all, but they don't even figure out that that was what happened for months. That was the Anderson case, and those are real life situations. Those of us who work in technology know that software and complex systems of all kinds need an iterative process of debugging improvement. Am I right? Amen, right? Anyone who uses technology knows that there are glitches and bugs and unintended consequences. And there's huge advantages to having independent third-party testing that's aimed at finding bugs. In other words, adversarial testing. If only those with interest in the success of software see the details, we have a huge problem and a recipe for injustice.
So black boxes and proprietary software and trade secrets are increasingly becoming a problem in the criminal justice system, as Gina was just explaining. I'm going to go through some examples of how that is happening. Obviously, I can't go through every possible example or every possible technology, as there are a lot and we have a very short period of time. Hopefully I don't talk too quickly and you'll understand everything I'm trying to say, as I will try to get across a lot of information. Just to start with, this is a graph, a chart from OSAC, which is, gives an idea of all the different forensic disciplines that come into play in the criminal justice system, some of them more scientifically reliable and accurate than others. So just kind of give you the playing field that's really at work here. For our purposes, we broke down a lot of the technologies into 4 different categories, but some of the technologies can fit in multiple categories. In particular, the line is really blurred when you talk about evidence assessment and evidence gathering. A lot of different things do both, and sometimes they kind of work together, and we'll talk a little bit about that shortly. I'll give you an example of at least one technology and cases in each area. But first I wanted to kind of break things down by secrecy level. And so there's 3 different levels that we've kind of identified, the most secret being secret. And in that situation, the law enforcement is saying, we don't even want you to know this thing exists, or if you know it exists, we don't want you to know that we have it. And secret as applied is, we have this, but we're not going to tell you how we use it. We're not going to tell you what cases it's been used on, and we're not going to say whether or not it's been used in a particular case that you're working on. And then there's the trust us, which is, okay, yeah, we have it, we used it in this case, but just trust us, it works the way we say it works. Don't look at the man behind the curtain, don't ask us any further questions, just assume that we're right, because why would we be wrong on something like this, as if we could never be mistaken, which we'll see has often not been true. And depending on your jurisdiction, some of these things switch categories, and also depending on, as time goes on, as we push more and more for transparency, hopefully we'll see less and less of these things up there. We're going to start with predictive policing. Predictive policing, in particular, is the idea that an algorithm or data can help make a decision or can make a decision that used to be left up to human law enforcement officers' own decision-making capabilities, which, in theory, that sounds great, right? Like you can remove the bias from this by removing the human element, but in reality, it doesn't work that way. Right? Because if the data that you're using to feed into, to teach this algorithm, or to get this algorithm to work the way you want it to work, is based upon prior past bad policing, like racist policing, or policing based upon class or gender, that the algorithm is going to learn it that way, right? And so, for example, if you constantly police the same area, and you make arrests, and you'll make more arrests in that area. So the algorithm starts thinking, oh, because you made more arrests in that area must have a higher crime, therefore more law enforcement officers are needed in that area, which then will also increase the arrests, which will then just be a circular logic and will just be self-fulfilling at that point, not necessarily the best use. Part of the problem with this is that a lot of this software and these algorithms are protected with non-disclosure agreements. The companies will claim that they're proprietary trade secrets and law enforcement shouldn't be allowed to tell anybody about what's going on. And they'll say that the underlying data that's being used is sensitive. All these things obviously prevent public scrutiny, which is increasingly becoming more and more important as it becomes more and more relied upon, and people's lives are being greatly affected in this realm based upon what reason am I being stopped? Because some program said that I needed to be stopped. And this idea that the computer is telling me, or the algorithm is telling me, you're removing the responsibility of humans is very problematic. In terms of evidence gathering, today we're really just going to talk about cell site simulators and mobile device forensics. Cell site simulators, for those you don't know, is essentially a device that mimics being a cell phone tower. And by doing so, it forces all the phones in its range to connect to it, and then it could very accurately and precisely pinpoint where that phone is actually located, including a specific apartment in a multi-story building, which is what happened in the US v. Lambus case. The reason why I say cell site simulators instead of Stingray device, which is what a lot of you have probably heard it called in the media and the news, is that a Stingray device is a very specific model. And all the models have different capabilities and have different limitations, and so I don't like to say Stingray because that's a very specific model that has very specific capabilities, where another device like a Hailstorm or a Kingfish or Triggerfish may have different capabilities. So besides also being used to track, some of the devices have the ability to intercept content, including voice calls and text messages. We know that the NYPD used one of these devices over 1,000 times between 2008 and 2015 without ever getting a warrant. Part of the problem with that is the NYPD still refuses to this day to tell us what model they have, and so we don't even know what capabilities is possible. And again, it's here where they're saying to us, trust us, it doesn't intercept content. We kept this thing hidden from you for years, but trust us now, that's not how it's working, which I think is ridiculous. And non-disclosure agreements between the companies that make it and the Department of Justice have been the main way that they've been keeping these things secret, or the main justification for doing so. We're going to talk shortly about a particular case out of Brooklyn in which I worked on where this became a big issue. So in People v. Gordon, our client was found in a location that really had no connection to him. And so our response was, well, how the heck did they find him there? How did they know he was there at that date and time, at that particular point? And so besides using some other cell phone tracking stuff, we came to the conclusion they really could have only done this, figured out where exactly he was with a cell site simulator. And in our motion to suppress, we said to them, we know you used this, and if you're saying you didn't, then tell us how you were able to accomplish knowing where he was in real time. Let it, and that precisely. Tell us how you did that. The prosecutor in his response conceded, yes, we used it. Which was a big win for us because this was the first time that we're aware of on a New York State case, on an open New York State case in which we were able to identify that they used this. Again, to this day, none of us actually have ever been able to hold one or see one or examine the software used in one. Based upon the prosecutor's concession, a few months later, the judge granted our motion to suppress an identification in the lineup as what we call fruit of the poisonous tree, meaning it was directly connected to an unlawful conduct because they had never gotten a warrant to use this. So we were really happy. We thought this was great. But even after this admission, after the judge's decision, and months of time for the NYPD to correct this, they then came out and said, no, you're wrong, we didn't use one. Well, your prosecutor openly filed something in court under oath saying that you did use one, and you had months to say that you didn't, and it was only when it became this public thing where a judge issued a decision that got published that all of a sudden you're saying you didn't. So even when we've come to that point where we've been able to prove this and be able to show this, they are still denying that they were using it. They still won't admit that it was used in a particular case, even though they haven't been able to come up with any other conclusion or any other reason for how this was able to be done. And the only basis I could think of is that they're still trying to abide by their non-disclosure agreement. So in terms of mobile device forensics, Riley v. California was the U.S. Supreme Court case that required a warrant to be obtained prior to going into somebody's phone and extracting data. A Celebrate YouFed Touch is a very common device that's used to actually extract data and make copies or make images of phones. And there's some other companies, Magnet and Parabin, who are also competitors and make similar products. This is not that big of a problem for us in terms of this being used, as this is something that is available to us. My office has one. There is some financial barrier for a lot of people, obviously, to be able to get one. But at least it's something we can test, we can replicate what they're doing, we could run our own version, and we could see exactly what they're able to do. And so it's available outside of law enforcement, so it's not as big of a problem to us. There's significant issues with the amount of data that it's collecting, but that's a talk for another day about overbroad search warrants and the judges signing whatever you put in front of them. But where we start becoming an issue is these secretive processes. Many of you probably remember the San Bernardino shooting in 2015. where the U.S. government said to Apple, you must put in backdoors in your encryption. You must help us be able to get into your phones and extract data. Apple says, no, we're not going to do that. And shortly after, the Department of Justice withdraws this request and withdraws litigation and says, well, all right, we don't need you. We got into the phone. And everybody says, well, you just told us a minute ago that was impossible, so what happened? Shortly after that, Cellebrite created Advanced Services, at the time Advanced Investigative Services, which is that it's a secretive process where the law enforcement agent sends the phone to them at their private lab. They conduct some sort of process that we don't know exactly what they're doing, and then they send the phone back to law enforcement unlocked with the encryption and passcode removed. Recently, a competitor called Grayshift has created a product called GrayKey, which does something similar, but instead of sending it off to a lab to be done, they actually sell a product directly to law enforcement. Law enforcement does it in-house. But the problem with both of these things is nobody will sell it to me. Nobody will let me use it. Nobody will let me have access to it. Not just me in general. I meant me as a representative of criminal defense attorneys and attorneys and the public in general. And so I have no ability to actually challenge it because I don't know exactly what they're doing. I have no ability to know what process they did and how that process worked. And so I don't know if the process made it deleted some really important information that could have been on there could exonerate my client. I have no idea if it may have changed some metadata. And to be clear, I don't think these companies would do anything malicious or intentional, but if code worked perfectly the way we wanted to all the time and there was no issues or bugs, this conference probably wouldn't exist. So we all know that that's what happens, right? And so there's no way, though, for me to be able to do that if I have no access to it and everybody says to me, no, it's a secret proprietary thing, but we're going to try to admit it into evidence when somebody's liberty is at stake. That is obviously a significant problem. So we'll talk a little bit about evidence assessment, in particular talk about facial recognition, which is becoming a more and more hot topic, especially now that Amazon has gotten itself into the game. As you can see there, the redactions are mine for the most part to protect our client's identity. But one of the problems we have with facial recognition, besides that, obviously there's a real significant problem about the accuracy of these programs and the algorithms. As I think was recently shown, it was identifying Congress members and stuff like that for the Amazon one. But the other part of it is that we don't know exactly how it's determining what is considered a match. And then we also don't know the procedure that they say this is a confidence level that's enough to determine that this should be admissible in a court. So if it's saying we think this is a 60% match, is that enough for it to be used to arrest somebody or to go into court? If it's 70%, what is the actual level that would be? And the problem is we're having law enforcement and these private companies do everything they can to keep that information secret and to keep that information from us. And the limited ability that people have had to test this stuff has shown a disparate effect on young people of color of being more likely to be falsely identified in this, which as a public defender, that makes up the majority of my clients. So that's a significant problem for us because they're already being over-policed and already being falsely identified. And now we're having a computer program in which they won't even let me see how it works or how it makes its decisions also being used in that space. To say that this blurry still image from a surveillance video matches a mugshot or even driver's license, depending on what jurisdiction you live in, if they allow that the picture from a driver's license to be used. I put up there the perpetual lineup. That's a really great report from the Georgetown Law Center on Privacy and Technology, which I highly recommend to everyone on this issue. So individualized assessments, in particular, I'm going to talk about sentencing algorithms. State v. Loomis, which Gina had alluded to earlier, was a case coming out of Wisconsin. The U.S. Supreme Court chose not to take it up, so it's not law across the country, but it's indicative of the problems that are going on everywhere. Essentially, the state of Wisconsin, the judge used a program called Compass, which is a risk assessment tool, to determine what the defendant, Mr. Loomis's sentence should be. And one of the things that was taken into consideration for that sentence was gender. The idea that men are more likely to be recidivists, meaning commit another crime after they've already been arrested and convicted of a previous crime. And so with that, it would be if you had a man and a woman both situated exactly the same crime, same history, same everything else, the only difference being their gender, the woman would be more likely to get probation, where a man would be less likely to get probation. That seems incredibly problematic for a country that's supposed to be equal rights, and your gender and sex are supposed to be irrelevant for that. The other problem, which then this doesn't just apply to Compass, it applies to risk assessment tools that are being used for determinations of how much bail should be set, if bail should be set at all, if somebody should be getting parole. Again, talking about sentencing here, and used in a variety of ways. A lot of times we don't even know what all the factors are that are being considered, or how those factors are being weighed in the consideration. In particular for Compass, how much did gender weigh into the determination of what the sentence should be? Was it a very minor thing, or was that the majority of it? But again, we have no ability to access that because they're claiming proprietary trade secrets, and unfortunately, the courts have not caught up to this yet, and it's becoming a problem with us fighting back against judges with that. This idea that something could be black boxed, or something could not give us, could not allow defense attorneys to challenge it when somebody's liberty, literally liberty, is at stake, it seems contradictory to everything that our Constitution and our criminal justice system is supposed to stand for. And I think the people here will say, you really can't know how well something works until you try to break it and take it apart. And here they're saying, that's exactly what we don't want you to do. From there, I'll let Nathan take over.
Hi, so I'm Nathan. My background is in computing, but I work for a forensic DNA consulting company, so I'm surrounded in a world of biologists. The forensic statistical tool is what we consider a probabilistic genotyping system, which is used to evaluate complex mixtures of DNA evidence. It was developed at the behest of the Office of the Chief Medical Examiner of New York City by a software company. And we didn't know a whole lot about it until less than 2 years ago. I'm going to take you through an introduction to that program, a review that we did, and a timeline of events as we have unfortunately learned after the fact. So FST is going to be one of the acronyms that I'm going to keep repeating. OCME, Office of the Chief Medical Examiner. This is the forensic DNA testing laboratory for the city of New York. I think it's the largest forensic DNA testing lab in the country. The FST program will evaluate DNA mixtures that contains DNA from 2 or 3 individuals, and it allows for missing data as well as the introduction of artifacts. So it'll attempt to account for both artifacts and missing data. That's the probabilistic part of probabilistic genotyping. It will report out a likelihood ratio as a numerical output, which is supposed to be the weight of the evidence that the jury is supposed to infer from this process. So the higher the number, the more incriminating typically, the lower the number, the more exculpatory it is, the more suggestive that the defendant is his DNA is not present in that mixture. It is a pretty straightforward C# and SQL web interface that has a processing backend on a server. In 2010, it was approved through the Regulatory Commission of Forensic Science for the state of New York. There's very few of these commissions in the country on a state level, but in 2010, they approved it for casework use. It looks at data on the human genome at 15 different locations. We call them loci, which I'll refer to again, and for mixtures up to 3 people. They originally intended it to be used on mixtures of 4 people, but that was too much data for it to, by their own measure, it was too much data for them to effectively interpret. So while they repeatedly publicly stated their intent to validate it for 4-person mixtures, they stuck to 2 or 3-person mixtures. It was brought online for casework use in April of 2010 and immediately brought offline. some functions were updated live as the system was being used on casework. An inadvertent change was made. They broke FST. We learned this last fall. It happened in 2011. We have also learned more recently that it was tested repeatedly in the summer of 2011, indicating that likelihood ratio values, these are the numerical outputs reported to the court, were modified as expected following a modification to the program. In 2017, the laboratory claimed that this modification did not affect the methodology of the program, despite reporting different values. FST is brought back online for casework in July of 2011, and a bunch of stuff happens here that we don't have time to go into. But in 2016, I'm part of a team that is the first outside glance into the inner workings of FST. It's a criminal case in New York City. It's a federal case. And the source code was ordered over for the defense to inspect. This is a part of an output screen from FST. So if any of you have seen CSI, this looks a lot more like TurboTax than it does CSI. If you look at the columns, these are identifiers for the 15 genetic locations that we look at for this type of forensic DNA examination. You have a reference profile, which is a particular person's DNA profile at these 15 locations. You have the evidence, numbered 1, 2, 3, so this is actually 3 separate tests of that DNA evidence that's being evaluated together and compared to this reference profile as a standard. The very bottom is a statistical weight that's calculated, and I'm going to describe what that number is supposed to mean. There are 4 numbers generated for every evaluation by OCME. They are broken down by subpopulation. There is a greater similarity between people of similar ancestry, so the breakdown used by OCME is Asian, Black, Caucasian, and Hispanic. The verbal translation of this number into something that's supposed to mean something is the evidence, that is lines 1, 2, and 3, the DNA profiles developed from whatever sample is being evaluated. The observed evidence is approximately 70.6 times more probable if the sample originated from reference profile, so a particular individual, and 2 unknown, unrelated individuals. This is the prosecutor's hypothesis that the defendant and 2 unknown, unrelated individuals contributed their DNA to the sample. The defense hypothesis is that it originated from 3 unknown, unrelated people, not including the defendant. So this is a characterization of the relative strength of these 2 hypotheses. The evidence is 70 times more probable if the prosecution hypothesis is true than if the defense hypothesis is true. This is a scan of a validation summary. It was provided not in digital form, so it had to be scanned in and manually clipped through. There is a library cart of this validation data that had to be manually scanned in. The reported value for this evaluation is 157 from the 2010 validation that was approved for casework use by the New York Commission on Forensic Science. In 2016, I ran this data through the version of FST provided to me in US v. Johnson. It produced the number 70.6 that I showed on the previous slide. These are different values. Sure.
Would the 157 be described as 157, in other words, twice as large a value, so it's 157 times more probable than the number you came up with?
The 157 is more incriminating than 70.6. Yeah. So through a series of steps that we can't go into due to time, we ultimately figured out that FST was not considering data at 3 of the 15 locations where results were generated for this evidence, although those locations had been considered during the 2010 validation. FST had been changed. The 15 out of 15 locations in 2016 calculates the same as the 12 out of 15 locations. So this is a false positive value. This particular analysis is a non-contributor to the mixture. The person whose DNA we're comparing to the mixture, because this is a laboratory-made sample during the validation study, we know his DNA is not present. But he has an incriminating likelihood ratio. It's above 1. So it seems like it might be a good thing that the modification made the value go down, made the likelihood ratio decrease. It becomes less incriminating. It's still incriminating, but it's less so. But the likelihood ratio for this one single locus, this one genetic location, is less than 1. FST was ignoring exculpatory information. These other 2 locations have likelihood ratios above 1, so it's ignoring exculpatory and inculpatory information. Several months after we identified this behavior, an assistant U.S. attorney acknowledged that this is occurring. This is not a software developer. This is not a biologist. This is not an employee of the Office of the Chief Medical Examiner. This is a prosecutor acknowledging that modifications were made to a software program. All of this was done under seal. There was a protective order that, had this not been vacated through the efforts of ProPublica and the Yale Media Freedom and Information Access Clinic, that's a mouthful, filed a request with the judge that the protective order be vacated. It was, because OCME did not oppose it. I don't know why, but here we are today talking about it. ProPublica then posted the code on GitHub. So if you have a copy of Visual Studio and Microsoft SQL, you can get FST running on your home PC. One of the issues here is that, as this was made public in October of 2017, 12 samples were originally evaluated with FST in August 2010 and then re-evaluated after the modifications were made in the spring and summer of 2011. 2 of these samples had 1 locus where data was dropped. We just examined a sample that had data dropped at 3 locations. There were 439 mixtures in this validation study. They only went back and did their version of a regression test on 12 out of 439. And only 2 of those had the data dropping function that is changing likelihood ratio values. More recently, records from 16 additional quality control tests, they're vernacular for a regression test or retroactive revalidation study, were produced. The main culprit for this change in functionality is only 70 lines, including comments and white space. So all of this is a very small change in terms of the lines of code, but as everyone here knows, that can be pretty substantial. To put this in context against the greater field of forensic DNA analysis and the growing field of probabilistic genotyping, I am not surprised that this occurred, that the story plays out the way that it does, that software was modified. 5 years later, it takes an outsider to identify that it was. It's then publicly acknowledged, and then it's backpedaled as to its relevance or importance. There was a case that I was involved in Washington State where the True Allele software was used. This is a commercial probabilistic genotyping system. The defendant, Emmanuel Fair, his team requested that the True Allele source code be provided, similar to how the FST source code was provided in the Johnson case out of New York City. Responses as to why this did not need to happen included the declaration of the software developer that there's no way to actually use source code in a validation study. Yeah. But it doesn't stop there. A professor of medicine said there's no reason to have source code unless someone intends to modify it. A supervisor in a forensic DNA laboratory said source code is not necessary for determining reliability of software because source code is typically not used to determine reliability of software. For forensic use, excuse me. A lab director of another forensic DNA laboratory clarified that DNA analysts only take one class in stats, and many of them don't have any foundational computer science knowledge. So the folks using the software don't necessarily know how it's constructed or how it should operate. He follows up with, it strikes him as irregular that we would single out one particular step of the whole forensic DNA analysis process. If one is to discuss error in DNA testing, then would one not want to capture an error rate for the entire workflow? So Gina's going to take it over again and describe some of our ongoing work in the field.
So we hope we've convinced you that us technologists, us hackers have a lot to say here and need to be engaging in this part of our society and need to be commenting and watching, right? One thing that we're doing this year is we got a grant from the Brown Institute. We're trying to tell this story to a general audience through exposés and journalistic pieces. We're trying to tell the story to a technology audience. Hello, that's you guys. We're trying to tell the story to a legal audience. We have a bunch of articles in a journal called The Champion from the National Association of Criminal Defense Lawyers that is all about the various aspects of this. And we are trying to do independent third-party testing of probabilistic genotyping software. As he mentioned, it's not just FST and True Illegal. There's a whole cloud of software. And shouldn't we be comparing one to another? I mean, if courts would have trusted any of them and they don't agree, what does that say about justice? And where we have access to source code, we are trying to look in the source code and find problems like the routine that Nathan heroically found in his look. But I'm sure there's a lot of other things that could be found. And we'd love your help with that. So what makes independent testing hard in this space? Well, one, it's really difficult to get access to the executables of the software. This software might not even be available to be purchased. As Jerome was saying, about many devices, you can't even get it even if you have a lot of money. Or if you can get it, for example, what replaced FST in New York, StarMix, I think it's $30,000 to buy it, plus like $5,000 of training, and then even, that's not talking about, that's just an executable. That's not talking about getting the source code or a database of bugs or testing plans or design documents or other things that as technologists we know would be really helpful to try to understand what's going on inside these black boxes. And on top of that, if you look at the terms of service, even if you can buy these things, oftentimes they say, there's limits on publishing the results or talking about it in public. And in general, there's this problem of trade secret protection. The intellectual property rights of manufacturers be considered to be more important even than the rights of defendants in criminal court. Like, did you think that was the way this country worked? So even under protective order, you can't go in and look many, many times. And I think oftentimes that is done to shield from legitimate questions of quality and fairness more than it's done to protect from competitors. Because there's already a huge first move advantage into a market just by admissibility into court and kind of a snowball of that. So all of this is thwarting the essential iterative improvement and debugging of these systems that would be absolutely necessary to establish when they can be used reliably and when they cannot be. And it is accountability, it's thwarting accountability to stakeholders beyond just the buyers. And in many instances, the interests of the people who are buying this software for use in jurisdictions is, of course, very different than the people being decided about. And there's really a need for natural repositories to share results and connect audiences. You know, Nathan mentioned you could download the FST source code and run it on your laptop, but that's, we've been doing that in our team as part of this Magic grant, and that's really hard. It's not just, you know, there's a lot of secret sauce. So, you know, how would you connect with us to know how to do that? How would you be able to report back to us what you saw? How would a defense team that's representing a client connect with experts who might be able to comment on the ways in which the things in the internals of the system might be relevant to that particular case? So we would really like your help. If you have learned something in this talk and you think there's other citizens and hackers who might be good for them to know this information, we'd love if you get them to watch the video. When software is being proposed for use, we have a procurement phase wish list. So when public money is being used for criminal justice software, require would be great, or at least give credit in the procurement phase for things like making your source code available, making software artifacts like bug data reports, internal testing plans and results, software requirement specifications, risk assessments, design documents, etc., available to the public. Or at least independent testing, but I say the public because it's too easy to corrupt an independent testing arm if it's not also public. No clauses preventing third-party review or publishing of defects should be in terms of service. Are you kidding me? Access to executables for third-party testing without, huge price tag. Oh, here's a big wish list item: scriptable interfaces to facilitate automated testing. A huge amount of what we're doing is, trying to put automated testing harnesses around these things so that we can run a bunch of cases all the way through. Bug bounties would be great. We would love in the procurement phase, for jurisdictions to contribute to a fund for third-party entities to do independent testing. These are all things. We'd also love for you to be a third-party reviewer. Please go check out the criminal justice software that is available. Things like FST on GitHub, as we mentioned. LabRetriever, LRMix, like LTD, Euroformix, those are all examples of software where the source code is available. Go look for bugs. Please tell us about them. That would help us. There's also predictive policing software, Civicascape, that's been posted. There are people who are making software who if we're making software in this space, it probably ought to be so open source because that's the nature of things in the criminal justice system. So take a look, find bugs, find bad smells in code, let us know. Also construct software for alternatives and comparisons. Many programs have algorithms published, replicate, and say, we're getting different results than you say you're getting. All of these things would be super helpful things for the technology community to do. And in the bigger picture, black box decision making is all around us. It's not just the criminal justice system. The criminal justice system is just especially offensive. There are big decisions being made about all of our lives in credit and hiring and housing and all of that list. And we would really encourage all of us as citizens and technologists and hackers to be pushing for algorithmic accountability and transparency in all of the things around us. The Association for Computing Machinery has a technology policy group that put out a set of principles, much like a code of ethics. So if you're building these things, you can point your team and your boss to people, to a list that says, this is why we should invest in these features, things like awareness, access and redress, accountability, explanation, data provenance, auditability, validation and testing. Be happy to point people to those principles and some explanation of them. But the basic idea is provide evidence that's needed to improve systems for all stakeholders, so that we're not running our society on buggy or possibly even malicious algorithms that are hidden from view. And I think in light of all the things we've talked about, that's enough evidence, isn't there? That there's bugs and problems and maybe even malicious stuff going on. The risk is just too high. We'd like to thank the people without whom our work would not be possible. And that includes 4 of us students who are working on the project, Marzia, Stephen, Abby, and Mariama. Maybe you guys can wave a minute. And our colleagues on the Magic Grant and the Brown Institute. Too many names here to list off, but now we'd like to open it up for questions. Yes.
Why isn't EFF up there?
So in that champion issue that I mentioned, I co-wrote an article with 2 folks from EFF. We could have put them in this list.
Well, no, I'm not saying you left them out. I was more saying.
So I would say that they're definitely in the space of people that we're talking to. So it was Stephanie LaCombra and Kit Walsh that the article I wrote was called Opening the Black Box. So yes, definitely involved in the space. Thanks for asking. Big shout out to the EFF.
I had a question if you could extend this to like gas chromatography or maybe mass spectrometry, some of the other measurements like that are used in other cases.
Absolutely. I think, as I mentioned, I just think we all need to be looking at the decision making around us that is being done in a black box way, and we need to be pushing back against that. Or we're entering a world in which our humans are going to be saying, oh, it's just because the computer said so. I don't know why you lose your job. I don't know why you go to jail. I don't know why this or that. We really need, as technologists, to be pushing back on this in all of those areas. Push in many areas as you can. I don't know your answer.
So you talked a lot about how we don't necessarily know how computers and software are coming to the conclusions they are, and how these conclusions are affecting human beings. Yes. However, if we didn't have these, instead of, say, the computer telling the judge what, like whether or not someone should be given bail or what bail should be set at, it would be the judge doing it with their own hidden biases that they themselves might not even know exist. And I guess the point I'm trying to get at is, I agree that the state of software in criminal justice is kind of a farce, but what makes it more of a farce than the criminal justice system currently is?
You want to take that one, Joe?
Yeah, I'll take that one. So I agree, as somebody who works in the criminal justice system as part of my job, that there's no question that judges and prosecutors and law enforcement have their own biases. I think two of the differences is, one, I'm not saying that no program should ever be able to be used. We're saying we should be able to know how it works and how it's making the decisions. Since we have the ability where it's a little harder for me to force information out of somebody's head, whereas the computer, we know we can review it, and so there's no reason for us not to be able to. Two, in regards to the comparison between a program and an individual, I think a lot of times people outside of tech people like us, when they hear a computer said this or that data has found this, they take that as like the word of God, where it's not very hard to explain to somebody that an individual may have a bias, because we all deal with individuals and we've had people lie to us or make mistakes, whereas people who are not very tech savvy often hear a computer said this is right and they say, oh, okay, and don't really think about challenging in the same way they would challenge an individual who made an opinionated or subjective decision. So I think it becomes more problematic. As soon as somebody hears DNA said that this person is a likely contributor to this, it's as if their brain shut off. Whereas when they hear a witness saying, yeah, I think that's the guy who did it, they're still more receptive to other information.
Really great answer.
I think there's a particular problem in these kind of quantitative assessment programs too that output a numerical result. That FST, that 70 versus 157 value, nobody questioned it. Nobody said this 157 should really be closer to 70. And when it was starting to, during the validation, and when it was going to 70 after the modification, after it was already in use, nobody said, you know, this should really be higher, like 150 or so. There's so little oversight. It's such a complex issue that our intuition about what's right or wrong about complex interpretation processes is so far removed that we just look at it. And when somebody has their evidence evaluated by a particular program that outputs a number, calling that number into question without offering your own number, I'm no lawyer, but that seems like kind of a weak strategy.
I think there's a lot of danger when you put algorithms that are trained on the way people did things or on historical data, which is flawed, into a black box and then call them unbiased, cool, logical decisions made by a computer, almost infallible. And especially if you're going to put them in that box and leave them there forever without iterating or debugging. And the only question you ask is, are we putting people in jail? Okay, good. Right? You don't ask the question, is it the right people? Or, you know, in this particular case, has there been a mistake made? If you don't get to ask that, that's a pretty big problem. Oh, I'm sorry.
It's good. It is kind of confusing. First, I told you I took a snapshot, and both my lawyers got hand claps and everything when they saw just the title for it. I did have two questions, and kind of ties in what he said. One is, I was a little confused because the title says, you know, innocent. I was wondering the cell phone taste where you were talking about where they use track. Was that they use that to make a person seem incriminated, or the fact they found a criminal, but you're objecting to the fact that the way they found him? And with your point there, we're constantly every day hearing that people are flawed, that we use our own judgments and bias, so we need to move to a system. And then we say we move to a system where, you know, it's just taking data and sampling, and that, hey, we did find more criminals in this area, you know, so ramp up. But then we're saying back again that, well, now we need a human to put their judgment inside there. It seems kind of cyclic that we're saying that human judgment is flawed, so we need a kind of a non-biased, cold, just analytical thing. But then we're saying, well, analytics can't put person and human emotion aside, so we need another person back inside there.
I'll respond to at least the first part of that. Well, obviously, he maintains his innocence, as somebody works as in the case. I also do as well. But that was more of a point to show the secrecy that oftentimes surrounds a lot of this technology, that we sometimes have an even hard time even knowing it's being used, and that even when it is being used, a lot of the issues that arise keeps us from knowing exactly how it's being used. For example, going back to that, we were told it was just used. Well, we were under the impression it was just used to locate an individual that was a suspect to be arrested, but they specifically didn't get a warrant, which seems problematic because that's kind of how our system ensures that things are done appropriately. And at the same time, I'm being told that I'm supposed to just trust them, that it wasn't used in any other way, which I have no reason to trust them especially based on their past history. And then even after all this, they still did everything they could to pretend that it didn't happen, didn't occur, which I think is kind of endemic to what's going on here with these non-disclosure agreements and these claims of trade secrecy that law enforcement is essentially acting on behalf of private companies to keep this information quiet and making it difficult for defense attorneys to actually do their job.
I think we have the potential to build systems that are more explainable, more audible, more fair, less biased. But just because there's the promise of that doesn't mean that what we won't really get is black boxes where mischief is hidden. That is an equally possible future if we don't insist on evidence and accountability and transparency and watching, right? We could just as easily get black boxes where mischief is held, and it serves the interests of powerful entities and it doesn't serve the interests of individuals. Now, we have a criminal justice system that we say cares about individuals and whether that individual is guilty or not. Are we going to continue to have that world or not? I think we really, that's what we're up against. And very similarly, I think it is very much kind of the question of our age, the mix of human decision-making and computerized decision-making. And I think there are ways that we can mix those together and get some of the best of both, but I also worry that we will get the worst of both if we're not careful. And I think investing in accountability and transparency and the ability to watch and question at this juncture is incredibly important. And that's why we're really asking citizens and technologists especially, to say, this is what can happen. This is how often complex systems are buggy. This is how much you need people who are looking at this kind of auditing information and debugging information and looking for the problems and fixing them. And, automated processing by itself, you invest in things that make kind of high-level demographic decisions rather than look at individual exceptions. So if the goal is just to make this a lot less expensive so we don't need as many people doing hard work, that's probably not going to be the recipe that gets us the system we want to live with, right? So I think there's still roles for people, but maybe the roles that people are taking are different. They are understanding and questioning the output. They're looking at how it applies to a very particular case. They are, doing more validation. Yeah, okay.
I think it was Jerome talking about the stingrays and the other devices like that. It seems like you're allowing the tail to wag the dog a bit, where I think if it's a person, you have the right to face your accuser. If somebody in the room accuses me of something, we'll go to court, and they're going to have to be in that audience or whatever so that my defense attorney can cross-examine. But now we have this class of person, which is the corporation, who says proprietary secrets. And it seems like you should be able to say, proprietary secret, you have a right to your proprietary secret, and we have a right to throw it out as invalid because you will not give us this information. Just like if the person accuses me and says, well, I know he's guilty, I just can't tell you why, that's going to get thrown out too, I would think. So it seems like the system is allowing these things to exist without proper auditing, and like a problem
we call
of your own
corporations people when it's convenient and not when it's not.
Yeah.
That doesn't seem quite fair.
I think you pretty much hit the nail on the head there, where that is a large part of our argument. The right to confrontation is a constitutional right, and we're being prohibited essentially from being able to actually use that right and protect somebody's right to do that, and that's a problem. And part of that problem comes back to something I said earlier, which is most judges are not tech savvy, and they hear computer said this is this, and they go, oh, it's a computer, and that's like the end of the questioning. And they basically, what you're just saying is something I'm trying to explain to them with varying levels of success, and so it's a real ongoing fight.
Thanks for the talk. It's been really eye-opening, and it feels kind of overwhelming. But in the short term, it seems like challenging these companies and getting access to source code and testing seems like the right way to go. But maybe in the long run, would it be better to instead have maybe the federal government fund development of open source tools that actually all local police departments or law enforcement can use, so they're not constantly rebuying the same products from all these other companies, and we have the source? So, thanks.
This has been heavily criticized from within at least the forensic science field, the members both inside and outside of the forensic DNA community that I've spoken with, because there's the idea that a grant will come down and open source software will be developed and then abandoned when the grant dries up. So it's abandoned where it's not supported, nobody gets training on it. And so there's this kind of knee-jerk reaction to the idea against an open source business model that you can either have protected software, protected source code, and generate revenue from selling it, or you won't have supported software. So that is kind of a parallel conversation that I think we need to have about how there can be opportunities, both public and private, for ensuring the ongoing maintenance and support of the software. But like, you understand what I'm saying? Like the open. So everyone in this room understands how open source business models can work, at least, right? Like, we've heard of some success stories, but we're not the group who's questioning that.
Please explain it to your legislatures.
Yeah, so this is certainly very eye-opening. I think this, I'm complete agreement that we need to challenge them. I mean, perhaps a situation where most of us face on a daily basis or semi-regular basis is, for example, a credit score. I mean, that's a great example of where you go to one credit agency and they'll give you a certain score and another one give you another one, and assuming that they have the same information, why should they be different?
Yeah.
And so these are scenarios where how do we know, whether it be in the justice system or in any of these organizations that have great influence on our lives, how do we know that they're doing it for the better of everyone, as opposed to maybe the party that might be most interested is those people willing to lend us money or whatever other situation?
Well, many times they are exactly doing it in the interest of those parties and not the people being decided about. That's kind of the point. And so it is a big problem. You know, I don't know how to get around it other than to vote with our wallets, vote really, you know, set an agenda that this matters. We're up against a huge problem of black box decision making all around us and huge impacts on our lives, and no real accountability to individuals, only accountability to, you know, governments and corporations, and that doesn't sound like the world I'd like to live in. So.
All right, we'll have to wrap it up.
She'll want me to ask this.
Okay.
So is there a place where you organize? So I saw a call to arms, but
Yep.
I didn't see where to bring those arms. And then is there a place, is there like an overarching organization where I can write a check that sort of you know, takes care of some of this? I saw a whole bunch of organizations there, but
Okay. So right now you could send stuff to us. We also set up a board, softwarejustice.boards.net, is that right? But we just set it up before this, thinking it would be nice to have a place we can all come together. I think we also set up softwarejustice.league@gmail.com. I'm not saying that we're incredibly organized, but we're working on it. And we would really like to see, you know, a larger entity come out of this to do general independent third-party testing. I have to have a big shout out to ProPublica and the kind of like data investigative journalism that they've been doing in this space. You could start by writing them a check, I think. EFF, you could write them a check. And you could help us stand up a, you know, credible independent third-party testing stuff. So you could start by sending me mail if you'd like. I'm easy, firstname.lastname@gmail.com. So gina.matthews@gmail.com. And we're giving this talk at DEF CON as well. And maybe between now and DEF CON we can get our call to arms a little more clear. So we were talking about, we had that exact conversation. But we're a small team, and we've been really busy doing this independent third-party testing. So if you would like to volunteer to help us get that right, come on up, and you could start with that. You could write checks to them, and you could get our board set up exactly right. Okay, thank you everybody for your excellent questions, attention, and interest in this important area.